Good evening, everyone. It's 7 o'clock, so we're going to go ahead and get started. My name is Kira Moog, and I'm the Family Engagement Specialist here at OPI. This will be our 6th community meeting this year, and we'll be talking about House Bill 450, Protect Physical Self-Defense in K-12 Schools, and Senate Bill 458, revising the laws to provide a common definition of sex when referring to humans. So please keep in mind, this is a friendly discussion. If you have any questions during the meeting, please raise your hand or type it in the text box. And as we have breaks and pauses, we will try to get those answered. Now, I want to introduce you to Rob Stutz, our Deputy Superintendent, as well as Chief Legal Counsel here at OPI. Rob will be going through each bill tonight and answering your questions. Thank you, Rob.
Well, thank you, Kira, and thank you everybody for attending. Glad to see so many people on. Rob Stutz, Chief Legal Counsel, Deputy Superintendent. Superintendent Arnson is not available this evening, but I'll be able to field as best as I can whatever questions you may have about these bills. As we start out, I'll just note that some of you may have attended earlier sessions of these community discussions, and thank you for coming back. There may be just a little bit of repetition as I step through the process for how we're going to go through these bills and how you can access them. I know we have members of the public who maybe aren't as familiar with looking at legislation or familiar with looking up the statutes, so we'll try to make this information available to everyone. So I'm going to share my screen. And what we have here is, sorry about that. We have the OPI website, and this is the front page, opi.mt.gov. And down the side here, you can see we have a number of resources. One of them is parent resources, and I'm going to click on that. And you can see the list of the different community discussions that we've had this year. We're at the November 29th one, and we've got a little agenda that's just going to show you the topics that we'll be discussing. As Kira mentioned, we are going through House Bill 450 and Senate Bill 458. I should mention that since our meeting last month, we've had the exciting development where these pieces of legislation have been codified into statutes. And so I'll show you how to access that language, and not only in the legislative bill form, but also how to access the actual statutes with the language that is the current law in Montana. The first bill that we're going to look at tonight is House Bill 450. And if you'd like to pull up the bill, and I'll post a link in the chat box, but I'll just also show you the process for accessing bills. You go to the legislative homepage, that's leg.mt.gov, and you can go to Laws and Bills, 2023 session, bill lookup. And you'll just type into these drop-down menus, House Bill, 450. And that'll bring up a page that has some information about how the bill became law. There's this table down here that shows that the bill passed the Senate by a vote of 67 to 31, and it also shows the earlier stages of the bill and how when those different events occurred, like committee meetings, hearings, and also the fact that it was signed by the governor and became law. And the language for the bill can be found right here by clicking on this PDF tab or icon. And so it's this language right here that I'm going to put into the chat so that anybody who maybe isn't following with the online process can pull up the language of the bill. But I'll keep it on my screen so that you can follow with me as we step through this bill. One thing I do want to note as we walk through the bills is that these pieces of legislation are the result of the hard work of the legislature. You may agree or disagree with the language of the bill and the policy reason behind it. My job tonight is not to advocate one way or the other about the legislation. That work was already done by the legislature, but rather to talk about what the language says and some of the considerations that went into that, and some of the ways that might apply to education in Montana. I also need to preface this by saying that this discussion is open to everyone, and we encourage you to participate, as Kira said, not only by raising your hand or putting questions in the chat box, but hopefully we'll have a nice discussion back and forth verbally, and a respectful discussion about the legislation and what it means. So also, my final little caveat is that although I am an attorney, the discussion we're having tonight isn't legal advice. If you have questions about how a particular piece of law applies to a particular set of facts, I encourage you to confer with your own legal counsel for that legal advice. All of that being said, we've got House Bill 450 pulled up. This is a bill by Representative Jedediah Hinkle, and I'll just note that Representative Hinkle is here at the meeting this evening, and may be able to answer questions if there are any about the legislative process. But this bill is designed to allow for self-defense of students who are physically attacked in schools. And so there are two parts to this bill. Section 1 was, my understanding, it was added as a result of an amendment. And what this says, the substantive part is the underlined part. That was the new portion that was added to an existing statute, 20-5-201. And this portion of the bill allows or prevents students who act in self-defense from being disciplined by a school district for acting in self-defense. Again, this section was not an original part of the bill, but was amended in during the legislative process. But the more actionable part of the bill, frankly, is the original Section 2, which is the self-defense authorization. And when I spoke with Representative Hinkle, he said that the thought behind this is if someone is physically attacked outside of a school in Montana, then they would have the ability to defend themselves without being subject to any penalty if they use reasonable force to defend themselves. Why are we potentially punishing school districts, or excuse me, students in school districts from protecting themselves if they're attacked at a school? And there were a number of individuals who spoke during the legislative session about situations they or their their children had faced at school. So the parts to this bill were the amendments to the statute that this bill authorized are in the bullying section of the statute. So that's what 20-5-209 is that's our code that addressed that prohibited bullying of students. And this bill provided the self-defense language. And there are two primary components of this language as far as what students can do. The first one, subsection 2, says a student who is physically attacked is entitled to use physical force that is reasonable and necessary for self-protection. So this addresses a situation where the student is being attacked. A couple things to point out. Number one, it requires a physical attack. So this wouldn't apply in a situation where someone might be verbally bullied. This would only apply to physical attacks. And so that's one key thing to keep in mind. Another thing to keep in mind is that this section refers to physical force. And we're going to contrast that when we talk about the next section, which talks about physical restraint. And then the final section that we want to consider is these words, reasonable and necessary for self-protection. And that was an addition that was recommended by the Montana School Boards Association to ensure that there isn't a disproportionate response to some sort of directed physical contact, a physical attack. Now, by placing this self-defense provision in the bullying section, I think that the legislative intent appears to be to draw attention to the issue of bullying in schools and ensuring that all students who are bullied and have the ability to defend themselves if attacked. That's subsection 2, referring to a student who themselves is physically attacked. Subsection 3 refers to when the student witnesses somebody else being physically attacked. A student who witnesses another person being physically attacked is entitled to use reasonable and necessary physical restraint, defined as the placing of hands on another in a manner that is reasonable or necessary to protect the person from physical harm. So subsection 2 allows when a student is being attacked, allows them to use force in their defense. When they witness another person being attacked, they can't use force, except they can use physical restraint to prevent that reasonable, necessary physical restraint to protect that individual from harm. So I want to just highlight that difference in the language. That was an important component of the legislation that Representative Hinkle pointed out to me when we talked about the bill. The last part of it doesn't refer, the last part of the statute and the last part of the bill doesn't refer to the conduct of the student so much as imposes an obligation on the school district to investigate that use of force and make a determination about whether the use of force was more likely than not in the protection of oneself or the protection of another person. So that is a provision that really looks to how the school district responds when an incident like this comes up to ensure that there was a physical attack, that the response was reasonable and necessary. And if that determination is made, then it says down here, may not reprimand or discipline a student if that investigation results in a determination that self-defense in fact had occurred. And it's that portion of the legislation that ties in with the earlier section that says that these discipline statute doesn't apply when students are determined to have been acting in self-defense. That's an overview of the statute. There isn't a whole lot of words, but there certainly is a lot to consider. I will note that the statute has become law. It was effective July 1st of this year. And so this is currently the law in Montana, at its heart, modifying the bullying statute to ensure that students have the ability to defend themselves or others who are being physically attacked. Are there any questions about this bill?
Representative Jebediah Hinkle, do you have anything that you would like to add to this at all?
Not really. Can you hear me all right?
Yeah.
Yeah, not so much in particular. I think Rob did a really good job explaining the bill. Yeah, I mean, he did a good job explaining why we brought the bill. I had situations where parents had contacted me frustrated with schools not enforcing their anti-bullying policies. Their children were repetitively bullied over and over and over for months. And yet, if the parents had talked with the schools and had said, okay, well, my child is going to defend themselves then, and the school says, well, then your child's going to be reprimanded for that. And, we just didn't feel that that was right, considering that Montana law the same student, if he was outside of a school setting and somebody attacked him or her on the street, could use physical force in the defense of themselves and be protected by Montana law. But as soon as they stepped into the school setting within those walls or on a school bus or school property, then all of a sudden that right to self-defense was gone. And if they did try to defend themselves, then they would be subject to the same reprimand or discipline as the person who actually attacked them. And we don't want to set that standard in school. We don't want to, because that actually gives the bully credibility. It gives the bully satisfaction knowing that they can attack somebody and that the person that they attack could be disciplined the same as them. So we put it in the bullying statute because we wanted to bring attention to bullying, and we want the schools to really take their anti-bullying policy seriously. And I understand that this bill does not address, does not address verbal bullying, cyberbullying. It does not entitle any student to take the first punch. So if a student is being bullied verbally and they decide to lash out and punch the person who is calling them names, this bill does not authorize that, and they would be subject to discipline. It only pertains to that situation where they are physically assaulted first and need to apply physical force to defend themselves. And then there was one other thing that I was thinking of. So this bill, so we put together this bill, and then the School Boards Association came and opposed the bill in committee, but brought amendment suggestions. And so what I did was I took those amendment suggestions. So a lot of the wording, reasonable and necessary, that came from their amendment suggestions. The language in subsection 4 there, school district, if you can scroll down, Rob, just a little bit more. It says a school district shall investigate a student's use of physical force and may not reprimand a student who is found through the investigation to have more likely than not. That was also language that they proposed. And apparently, I think some of this language may have come from like a handbook, teacher's handbook, or like a school policy. And I was told that that is the language they use in their policies, and some of it applies to what a teacher, I guess what a teacher is permitted to do in a situation where two students may have a physical altercation. And so a lot of that subsection 3 is taken from that language where a teacher is able to use physical restraint. The teacher is able to step in and break up the fight or pull one student off of another. And so that's where that language came from. So, but at any rate, I think the purpose of the bill is to draw attention to bullying in school and to make sure that a person who is bullying or feels that they have to use physical force to protect themselves physically does not have their hands tied behind their back with school policies that would deny them that opportunity.
Well, thank you, Representative Hinkle, for that explanation about some of the thoughts that went into the bill and some of the legislative process. Are there any questions from members of the public about this bill for either the OPI staff or for the representative? Here, I don't know if you can unmute Sharon. Hand
Yeah.
raised.
Yeah, I'm unmuted. Yeah, I have a bunch of questions. Having spent 20 years as a vice principal, this bill is really interesting. What happens if, okay, I make a decision as an associate principal that in fact a child wasn't defending himself, but it in fact joined in willingly the fight? And that is my decision as an administrator, although the parents might not agree with it. What happens?
Well, that's a great question, and I think that that is addressed in the portion of the bill that says they may not be represented if they are found through investigation to have, more likely than not used physical force for self-protection. If they didn't use it for self-protection, then um, this sentence down here wouldn't apply. And then the remainder of this statute does apply, right? A pupil who disobeys the provision of this section harms or threatens to harm another person or another person's property, or otherwise violates this, is subject to punishment, suspension, or expulsion. And so if a student claims self-defense, but the determination is that they were the or one of several aggressors, then they would be subject to the same types of penalties that would apply to any aggressor.
So that doesn't sound any different from what I did for 20 years. Could
So,
you explain to me how that would be different from the law that I had to follow and followed at that time?
so if I understand your question, you're saying that this this process was the process that you followed, even though there wasn't a specific statute that addressed self-defense. Am I understanding your question right?
Well, honestly, if a child was truly, as an administrator, I investigate. If I find that the child has done nothing and was simply defending himself or herself, then I would know that was self-defense and not punish the child. I didn't have to have a law to tell me that that was self-defense, and I didn't have to punish the child.
If I can,
And
if
so
I
I
can
just,
interject, I think Representative Hinkle would like to address this question.
yeah, and we'll get to that in a just a second. I just want to point out that so what the law does is it codifies the process that you followed, but you might not have been your experience might not have been typical. I believe that there are parents who testified that their kids were reluctant to defend themselves because there was this concern that they might be identified as the attacker. But on that note, Kira, thank you for pointing out that the representative has his hand raised. Representative Hinkle, did you have thoughts on that question?
Yeah, thank you. And thank you for the question, Ms. Patton. I'd like to thank you for the way that you run your school and the investigation and how you would make your determination. And here's the catch is that not all schools have the same policy and not all schools address these situations the same. A number of schools have zero tolerance policies, from my understanding, where it doesn't matter. If you fight, you will be disciplined, period. It doesn't matter whether you're the attacker or whether you're the person that's attacked. And I think, the parents that brought this issue to my attention came from schools where they had that zero tolerance policy. And they were literally told by the school, if your child disciplines himself, or protects himself, defends himself, he will or she will be disciplined the same as the person who attacked them. So, I would like, it would give me great comfort to know that most schools investigate and pursue, I guess, determinations and disciplines as you have, but it's my understanding that not all schools do that. And that is why this law is put into place, to make sure that equally across the board, doesn't matter what school you go to in the state of Montana, that if you have to use physical force to defend yourself from being hurt, then you can do that without having repercussions. As long as it's found in through the investigation. So this bill still does give the school quite a bit of discretion because they are the ones investigating and maybe talking to witnesses or whatnot. But through that investigation to make sure that they're not disciplining students that are protecting themselves from physical harm.
Are there any
Well,
other questions?
Yeah, thank you for your answers.
Okay. Sharon, did you have another question? All right. Does anybody have another question?
We did have a comment. Someone said investigation of reported incident is of course appropriate, but will be hard to determine actions unless witnessed.
Yeah, no, that's a good question about the type of information that would go into an investigation. And investigations aren't always easy. You sometimes find a situation where two parties to a situation have testimony that's in conflict or statements that are in conflict. And that is the investigation process is not something that's new to this legislation. There are a number of situations, not just self-defense, but everything from academic issues to harassment issues to other types of issues that school districts do have a process for investigating. So I appreciate the interest in how that process moves forward and what type of evidence that a school district can consider. But it's not unique to this piece of legislation. Excuse me. Well, before we put a bow on this, let me just show you that this amendment to 20-5-209 I mentioned earlier is now live online. You can go to the legislative webpage. It has the 2023 Montana Code annotated. And if you go to that site, you can just navigate to the citation. So the numbering system, 20 is the title, 5 is the chapter, 2 is the part, and 209 is the section. So if you go to the Montana Code annotated, that's our set of laws. You can go to 25, part 209, and you can see where this language from the legislation has now been codified into the language in the statute that's the law here in Montana. That's not something we were able to do at the previous community discussion, but now we are because those bills have been codified. All right, well, thanks everybody for the discussion about House Bill 450. We're going to move on to the next item on our agenda. That's Senate Bill 458 that defines sex in Montana. And we're going to use the same process to look up the bill. So we're going to go to the legislative website. We're going to say bill lookup, Senate bill. And I should mention that this bill from Senator Glim, I did not have the chance to talk with Senator Glim about this bill in advance. And so I might not be able to answer some of the questions about the legislative process. I didn't participate in this bill. One thing to note is that this bill, unlike the bullying bill that we just looked at or the self-defense bill that we just looked at, this bill is not specific to school law. School law is in Title 20 of the bill, and this bill, the bulk of the impact of this bill, or the bulk of the substance of this bill, is found in Title 1 of Montana statutes, and that is part of the statutes that has really broad information for how the code is interpreted and applied. And in this case, the bill has a definition under what is called the terms of wide applicability. And that definition means that wherever you encounter these words in the Montana Code. These are the definitions that apply, and unless it's more specifically defined somewhere else. And so just structurally, when we look at the bill, you can see that this bill has the amendment at 11201, and then it has a number of amendments throughout other titles of the Montana Code. And I'll just cut to the chase, I suppose, it's the amendment in 11201 that really has the substance of the bill, and all of those other amendments are to statutes that reference sex or male or female. So those changes are simply changes to the reference of the definition of those terms. Those sections aren't substantively changed in any other way. So almost all of this bill, which as you can see is over 60 pages long, almost all of the bill is just cross references to the definitions that are presented here in section 1. Before we dive into those definitions, the one thing that they did add to this bill is down here on page 61. They added at the very end a severability clause. And what this means is that if one portion of this legislation is found to be invalid, the other portions are not automatically found to be invalid. Only those portions that are found to be invalid are severed, and the remaining portions remain valid. So I just wanted to point that out, that this statute does have a severability clause. So for example, if one of the definitions is found to be invalid, it doesn't mean that the other definitions added through this legislation would be invalid. Or if one of the cross references, here's an example of the cross reference. If one of the cross references is found to be invalid, it doesn't mean that the underlying statute with defining sex or male or female would be found to be invalid. So that's just you don't see that in all legislation, but it's one that was in this bill, and just wanted to point it out. So jumping back up to the top, a couple things. There's the definition of female, the definition of male. Those are based on biological definitions that are established at birth. And I recognize that this view is controversial. I believe that that controversy played out, but both in the legislature and may also be playing out in litigation. So we're not here to sort of litigate issues that may be presented and decided by a court. But at the heart of this piece of legislation is, in my view, is right through here where it talks about in human beings there are exactly two sexes, male and female, and that the sexes are determined by biological and genetic indications present at birth. So this takes this establishes as the definition of male and female those biological and genetic views that are described here under the definition of female and male. And that's really the heart of this legislation. Although the remaining 60 plus pages talk about the application of those definitions in certain specific statutes. At its heart, this bill is about defining sex as being one of two sexes, male or female, with very specific definitions established at birth. You should note at the end of the definition of sex, it says, without regard to an individual's psychological, behavioral, social, chosen, or subjective experience of gender. And so that's making clear the distinction between sex and gender. It's subject of much conversation here in Montana and around the country recently. And so with that overview of the bill and the language and the impact of the bill, are there any questions from members of the audience, or perhaps just discussion about things that they see in this bill?
Once again, if you have any questions, you can type them in the chat box, or you can use the raise your hand feature.
Well, while folks are considering the questions they may have, I'll just also step you through so you can see how this language in the bill, and again, it's the underline, that's the new language, and the strike throughs are language that has been deleted, and you can see here they added A and B, so they had to renumber the other subsections. But again, we would go to the 2023 Montana Code Annotated, and you can jump right to 200s, and you can see that this statute 201 is part of a series of statutes that define certain widely used words in the code. And so when you click on terms of wide applicability, you could see where these legislative definitions that were part of the bill have now been codified. That means put into the code as the statutes in Montana, female, male, and sex being the ones added by this legislation. While you're considering questions, we'll just step through a little bit about the history of this bill. You can see that.
Actually, Rob, we do have a question.
Okay, great.
Representative Hinkle posted a question. He said, has the issue been brought up with transgender students using a bathroom that is designated opposite of their biological sex / genetics?
Yeah, so that's a question that probably comes up from time to time in school districts, and how those school districts handle them, no doubt would be in consideration of not only the law, but whatever legal advice they get from the school district's attorneys. OPI doesn't provide that type of legal advice to school districts, but we certainly are happy to share general information about what the requirements of the statute are and let those school districts confer with their counsel about how that might apply to whatever situation they're facing. So I'm confident that that question has come up. I'm just not confident how individual school districts have addressed it. But certainly if they were to call, we would point out, the legislation and the statutes that we're aware of, and strongly recommend that they confer with their counsel about how to address that. So I was gonna, while other folks consider questions they may have, I was just gonna step through the history of the bill a little bit, and you, excuse me, you can see where it passed the House. Its third and final reading by a vote of 28 to 22. You can see that vote narrowed somewhat from its second reading, where the vote was 31 to 19. And again, similar splits by about 60% margin in the Senate. When it passed, signed into law by the governor. And I suppose we should also note that this bill, unlike the previous bill, this bill does not have a specific effective date. And so under the laws of Montana, that if a bill of this nature, general law, doesn't have a specific effective date, then it would become effective on October 1st, which means that this bill became effective October 1st of this year. Here, are there any hands raised or other questions in the chat?
Not as of right now.
Okay. Well, I don't want to keep people on this Wednesday evening longer than is necessary for the conversation, and I do appreciate everybody coming out and walking through a couple of pieces of legislation with us. Our self-defense bill for schools, and then our definitions of sex, male and female, that has a broader application to all of the Montana code. I will note that we do have another discussion coming up on December 3rd. And in that one, we'll be talking about a very education specific bill. That's the Early Literacy Intervention Bill, House Bill 352. Because of the holidays, we'll be having that community discussion earlier in the month than we typically do. So we look forward to folks coming back on December 13th for a conversation about the Early Literacy Intervention Program that OPI and the Board of Public Education are working on as a result of this bill. Thanks everybody for coming out this evening, and we hope to see you at our next community discussion.
Thank you.